Okay, good morning, everybody. It's 10 o'clock, so time for me to open the hearing sessions as part of the examination of the Dacorum local plan. First of all, can everybody hear me? Can everyone hear me in the back? Yep, very good. Well, good morning and welcome, everybody. My name is Matthew Birkinshaw. I'm one of the appointed inspectors, and alongside me is my colleague, Mr. Thomas Bristow. We're both chartered town planners and we're both appointed to the examination of this local plan. So throughout the various weeks, you may see one or both of us attending the examination. I'll quickly run through some housekeeping and procedural matters, but before I do so, could I just ask someone from the council just to quickly run through any fire and emergency procedures that people in the room need to be aware of?
Thank you. The fire alarm test takes place on Tuesday mornings at 9:30 a.m. We're not expecting a further fire alarm today. The fire evacuation alarm in the forum is a voice alarm system rather than a traditional siren. The alarm will announce that the building must be evacuated due to an emergency. On hearing the fire alarm, everybody must immediately leave the building by the nearest available route. From the first floor, as you leave the conference room, there is a staircase immediately opposite the council chamber to the right. An alternative route is available to the left, past the lifts, towards the registrar's office. Please follow the fire marshal. If in the event of a fire you would need assistance in using the stairs, please make reception aware. The main assembly point is at the Market Square. Moving on to toilets. There are toilets located on the ground floor and on the first floor of the building. On the ground floor, they are located by the cafe. On the first floor, they are to the left as you exit the conference rooms after the lifts. The hearings are being live streamed and recorded to be made available after the session. Please be aware and leave the council chamber if you do not wish to be filmed. Thank you.
Thank you very much. Also in attendance today is the Programme Officer, Louise Sinjinhow, who's sat to my right-hand side. No doubt you'll have been in touch already with Louise with regard to attending today's session. If you have any queries about documents, the library, the sessions, which session you should be attending, any of those sort of housekeeping matters, please do speak to Louise. She'll be around every day of the examination, or if for whatever reason she's not, then her contact details are online. So any questions or queries about the examination whilst we're in the room, or which session you should be attending, please do speak to Louise or raise it in one of the sessions. As this is the first morning of the examination, before we sort of go around the room and introduce ourselves, I'll quickly run through some sort of procedural matters. Bear in mind, some of you may have heard this before, but I'm mindful that there's people in the room who may not have heard this before or who not have attended a local plan examination before. So our role is to determine whether or not the local plan meets the legal requirements and whether or not it is sound. So today we're going to be looking at some of those legal compliance matters. We're looking at things like the duty to cooperate, public consultation, habitat regulation assessment, things like that. As the examination moves on, so tomorrow we're looking at the sustainability appraisal and some of the strategic matters, and then we'll be looking at Greenbelt. So we'll sort of be, after today and tomorrow morning, they're really the legal compliance matters. We'll then be into matters of soundness. So in order to be sound, what does that mean? Well, in order to be sound, the National Planning Policy Framework states that plans should be positively prepared, justified, effective, and consistent with national planning policy. So throughout the examination, you'll hear that word referred to a lot, test of soundness. So that's what we mean, and that's set out in the National Planning Policy Framework. I'll now move on to talk a little bit more in detail as to what the hearings are about and the format of them and what we're here to discuss. So the hearings are an opportunity for participants to put their points forward. It's also an opportunity for Mr. Bristow and I to test the evidence and to test whether or not the submitted plan is sound. Now, we have got all the representations. We've got all the Regulation 19 representations. We'll take those as read. We don't need to go through those in any detail. We've also got everybody's hearing statements for those of you who have submitted statements. So again, it's not really the purpose of the hearing sessions to sort of read out or present any evidence or sort of cross-examine anybody. It's not really like that. What will happen is Mr. Bristow and I will work through the matters, issues and questions for each session. Some of the larger sessions will probably set an agenda. I'm more thinking around Helm Garden communities, but for the purpose of this week, there's no set agenda. We'll use the matters, issues and questions document and we'll work through those. So again, either myself or Mr. Bristow will ask questions of the council. Typically, if people want to join in at that stage, I don't know how this started, but the done thing normally is sort of put your nameplate on an end so I can see who wants to speak and I'll bring you in at the appropriate point. They are public hearings and we want people to participate and we want people to engage. However, please do stick to the points that you've made in your representations. So if we're talking about a particular issue or a particular site and you haven't made any points about that, then Mr. Bristow and I will probably politely tell you now is not the opportunity to raise those points. So we want you to engage, we want you to participate, but please, in the interest of fairness, only stick to the points that you've made in your representations. The hearings aren't an opportunity to sort of jump on the back of other people's reps or make additional points that you haven't already made. We'll have breaks throughout. So today's session obviously starts at 10 o'clock. Please do look at the programme, check the programme, because other sessions do start at different times. So I think notably for the rest of this week, I'm looking at Louise to nod at me. The rest of the sessions start at 9:30. She's not listening, but they start at 9:30. But please do check the programme. And if people are unsure about what session they're in, again, speak to Louise, call Louise, email Louise, and she'll help you out and make sure that you're in the correct session. But the way the programme is ordered isn't necessarily the order of the plan. So please do check the programme and please do make sure that you're in the right session. We'll break mid-morning. We'll probably break throughout the examination hearing sessions. If anybody needs a break, just let me know. Just say. I'm not going to keep you here all, oh, we could have a break. Just say we'll have a break. It's fine. We've got all day for most of the hearing sessions. I think it's tomorrow that we need to be gone by 5 o'clock for a planning committee meeting. Thursday. Yeah, that's fine. But yeah, please do let me know, and we can schedule breaks. We'll aim to finish again. See how we get on. We'll normally break about 1 o'clock for lunch. Come back at 2 o'clock again. A lot of the sessions are split, so the afternoon session will be different. So just again, keep an eye on the programme as to which session you need to attend. Slightly uniquely, there are 3 stages, or there will be 3 stages to this examination. Stage 1 is effectively this week. So stage 1 is legal compliance and strategic matters. So we're looking, as I said before, around issues such as duty to operate, sustainability appraisal, site selection methodology, and the green belt assessment. So that's effectively stage 1. And after that, if we had concerns about the council's engagement under the duty to operate, we would raise that with the council. So we'd write formally to the council after stage 1 and say, hang on, we've got some concerns. We don't think they should go any further. That's why it's set up like that. Stage 2 is a week in October, off the top of my head, week commencing the 20th of October, where we are looking at strategic matters relating to Hemel Garden communities. So that's a joint session with St Albans Council. For those of you who are interested, Mr. Bristow and I have already started the examination of the St Albans City and District Local Plan. We started that in the spring. So the 2 plans are more or less-ish at about the same stage now. So this week's stage 1. The week in October is stage 2. That's looking at strategic matters around Helm Garden communities, i.e. why is the council doing what it's doing? Have you considered strategic highways impact? Have you considered strategic infrastructure? That's stage 2. Stage 3 for this plan, so stage 3 for the Dacorum plan, will be held later this year. We haven't notified precisely when the dates will be. I can sort of let you in on a bit of a trade secret. It's probably going to be November, December, realistically, if everything goes to plan. Obviously, Mr. Bristow and I can't be in 2 places at once, although we'll try our very best to be. So I think realistically, this week, stage 1, week commencing 20th of October is stage 2, and then stage 3, when we're looking at site allocations, we're looking at the specific allocations in this plan, we'll will be held probably in November and December. That's the plan. So that's a sort of a real sort of rough outline of the stages and the sort of next steps, really. I'll talk a little bit about our role and what we do as part of a local plan examination. So, as I said, we're here to test matters of legal compliance and soundness. It is not our role to make the plan better. We can't say, well, it would be a bit better if it was reworded, or it would be a bit better if that site was a bit bigger or a bit smaller. Our role is to consider whether or not the submitted plan is sound, and we work on the basis that the council has submitted a sound plan. That's the starting point. The council submits a sound plan, and we test whether or not it's sound. We can recommend changes to the plan. So again, throughout the hearing sessions, you'll hear to something called main modifications. So we can recommend main modifications, and it's only ourselves that can recommend those modifications. Once the council submits its plan, it cannot make any substantive changes to it. Only ourselves, through main modifications, can change the plan. Now, generally, what I do as part of our examinations is I like to have a bit of an open and honest discussion about something. If we think something is unsound, we'll probably say it, and we'll have an honest discussion around, I don't think that's right. We'll come on this afternoon to talk about housing requirement, for example. I think we've already laid our cards on the table that, you know, what we think about the housing requirement and the plan period, so we'll come on to talk about that. So that's main modifications. Now, the important point for representers, main modifications will be consulted on. So we can't just sort of make changes to the plan and no one can participate. Any main modifications we make will be subject to consultation. So the council will have to go away and they will have to consult on those changes for the full 6 weeks, as they did when they consulted on the plan. So that will be all set out, everyone will be notified, everyone will have an opportunity to comment, and then those comments will come back to us before we ultimately reach our final conclusion on the plan. So when we're talking about changes, it's in the context of these are things that we think should be changed, but that's obviously subject to consultation. So that's just a little bit of a sort of procedural point there. Now, the council can make changes upon adoption, and they're typically minor changes, typos, spelling mistakes, factual updates, things like that. They can't change any substantive policy text. They have to come through us, and they will be subject to full public consultation. That will also need to be subject to sustainability appraisal. And my advice to councils is, if in doubt, essay it, basically. We'll come on to sustainability appraisal. And if I could ask the council as well, typically what I ask of councils is, as we go through each day, if you could nominate somebody within your team to make a running list of changes that we've discussed. Again, it doesn't need to be, this is what the policy says, this is what we think it should say, just a bullet point headline. We talked about policy H1 and it should change for whatever reason. A real high level bullet point list. And if I could ask you to send that through to Louise at the end of each day, just so we've got a running working total. And again, also, if we agree through the hearings that some more evidence is needed. So let's say, for example, something needs to be done to the SA. Again, if you could just keep a sort of a homework list and a main mod list and just send that through to Louise, that'd be really helpful, just to help with the sort of running of the examination. Now, I know several of you here today will be, and throughout the course of the hearings, will be here to discuss emission sites, our favourite topic of the examination. Emission sites are not in the plan. We cannot discuss the soundness of those emission sites. It's not our role to say to the council, you've allocated this site, what do you think about this one over here? It looks a bit better, should you not have allocated that? That's not our role. We're here to consider the soundness of the submitted plan. Now, it does get a bit of a grey area because, especially for this week, as we go into sustainability appraisal, that obviously requires a consideration of reasonable alternatives. So naturally, there's a bit of a discussion around what did you look at? Did you look at that in sufficient detail? Did you test it to an adequate level? So I get it, that's where there will be a bit of discussion. However, it's not our role once we come on to the sort of the detail of the plan to say, you should have allocated that site rather than that one. So that's something to bear in mind. And Mr. Bristol and I are pretty, we're pretty laid back, but we will just say if anybody does stray into sort of presenting the merits of their admission site, then we'll politely sort of cut that down. That's not the role of the examination. That's not what we're here to talk about. Equally, Greenbelt assessment, again, I appreciate site selection methodology. Again, there's a bit of a sort of, well, you followed this methodology and it sort of gave you this site, whereas you followed it and it didn't give. So I get it. There's a bit of, examples need to be given. And we'll take a bit of leeway on that. But generally speaking, we're not here to discuss admission sites at all. We're here to discuss the submitted plan. And it goes so far as to saying as well, if we go through this process and we conclude the council doesn't have enough housing land, for example, again, it's not for us to say, you haven't got enough housing land, what about this when it's really good? That's not our role. We'd be going back to council and saying, you haven't got enough housing land, what should you do about it? And it would be for the council to come up with alternatives. It would be for the council to come up with their suggested ways forward. That would be the process. Again, it's not our role to promote emission sites in that way. I'll quickly talk about policies maps, but only very, very quickly. Changes to the plan often result in consequential changes to the policies maps. So at the main mod stage, you will have effectively a schedule of main modifications. You'll have a schedule of additional modifications, which we don't really need to see. That's your changes, that's the typos and things like that. And you will also have changes to the submitted policies map document. So any changes that we talk about that result in changes to a site allocation, or the deletion of a site, anything of that needs to be obviously mindful of any consequential changes to the policies map. So a separate document will be needed to show participants any changes to the maps as well. I won't get into nuances about whether it forms part of the development plan, etc. We'll save that excitement for another day. But the main thing to realise is you will need to show any changes to the submitted policies maps. That's a very brief sort of overview of our role, the examination, what we're going to be talking about as we go through the hearings. What you will find is that the hearings are arranged in a way whereby there will be a crossover. So we'll talk about the essay tomorrow morning. That sort of fits nicely with site selection, spatial strategy. So again, there's a bit of a crossover there. Later in the week, we're talking about the Greenbelt methodology. So again, that ties in with site selection methodology. What did the council do? Which sites did it look at? How did they consider the Greenbelt? So there is a natural crossover between some of the topics. So again, when I say please stick to your points, I appreciate there's a wider point that some of these topics cross over. What I will just say is, and it's not because we don't want to talk about them, but the specifics of sites, the actual allocated sites in the plan, we won't be getting on really to talk about this week. Obviously, we will have in future stages, and it'll be in stage 3, specific sessions on each of the allocated sites in the plan. So it'll be a specific session, say a morning session on site A or site B, and there will be dedicated time to talk about that. So don't panic if you think, well, the inspector's really not considered my points about this site. It's not that we've not considered them, it's just that's for another day. Talking about strategic matters this week, we'll come on to the sort of the nitty-gritty of sites and whether or not they're justified and sound, and looking at sort of highways and transport and infrastructure. That will come in stage 3. That's where that will sit. Before we go around the room and ask everyone to introduce themselves, Tom, have I missed anything of importance?
No, not that I can think of. It was just a reassurance. I think you said it. There are people presumably watching online. We don't know how many, but just to say that we've taken account of everything in writing. There's no difference as to how we treat anything, whether it's made here or it's made in writing. So it's just a reassurance for people at home. But no, thank you.
Yeah. No, Ms. Bristol makes a valid point. Obviously, yes, participate and engage in the hearings, but it doesn't carry any more weight. We will obviously take into account written representation as well. And I think a couple of people have done that this week. They've made statements and have said, we can't attend the session, but can we rely on our written submissions? And yes, of course you can, and they will still be taken into account. And just because I fell foul of it as well, which is a timely reminder, the microphones, it's a simple button on the right, flashes red to speak. When you finish speaking, please make sure you then disengage the microphone, which allows the next person to speak. Okay, so I've introduced myself, Louise, and Mr. Bristow. So I'll now ask everybody to sort of go around the room. I'll start with the council. If you could introduce yourself, if you could let me know who you are, whether you represent a particular client or a particular residents group, and what your main interests in today's session is. And then after that, I believe the council would wish to make an opening statement. So we'll go around the table, ask everyone to introduce themselves, and I'll hand over to the council who wish to make an opening statement.
Thank you, sir. Moving from your left to your right, my name is Craig Howell-Williams of King's Council. Sitting behind me is Mero Golden of Council, and we are both part of the Council's team.
Good morning, sir. My name is Ronan Layden. I'm Head of Strategic Planning here at Dacorum Borough Council. I oversee the delivery of the new Dacorum local plan.
Morning, Claire Covington, and Planning Policy Assistant Manager at Dacorum Borough Council with an interest in HRA and climate change.
Good morning, sir. Miss Melissa Murphy, King's Council. I'm here to represent Dacorum Homes Limited. You've had our hearing statement, so you'll know our primary area of interest. We're here to help with, if we can, with duty to cooperate primarily this morning.
Good morning, sir. It's Rhett Flashman, planner at Dacorum Homes, covering the same matters of interest that Melissa Murphy has picked up on.
Morning, John Bell, representing Eco Burco. Main interest today is climate change.
Good morning. My name is David Churchill. I'm a partner at Carter Jonas. I'm representing Crowd Ace Homes. Principal interests is everything that's on the list, predominantly focused on housing and the accommodation of suitable housing numbers.
My name is Hugh Siegel. I'm a part of the Berkhamsted Residents Action Group. Our interest basically is in the whole process of the plan. You have our written submission, and we will follow the whole thing from start to finish. Thank you.
My name's Anthony Harbidge. I'm also Berkhamsted Residents Action Group, and Hugh's covered our thing, and you have our statement. Thank you. Go off. I'm pressing the left one.
Jacqueline Vita. I'm here representing CPRE Hertfordshire. There's three things that we want to cover specifically today. Some issues with public consultation, the impact of climate change on loss of sites in the Greenbelt, and the HRA and the use of SANGs.
Thank you, sirs. Good morning, everyone. My name is Ronan Layden, and I'm the Head of Strategic Planning here at Dacorum Borough Council. I would like to welcome you, sirs, all the participants around the table, and members of the public who are observing here today in person and online, to the first day of the examination in public for our Dacorum Local Plan to 2041. I hope that you will find the forthcoming discussions both helpful and constructive. Work on the new local plan commenced in 2017 with a consultation on issues and options. From there, the plan evolved alongside new evidence to become a full draft plan that was consulted on in late 2020. A further targeted consultation on a revised strategy for growth was consulted on in late 2023 before the Dacorum local plan was finalised for publication under Regulation 19 in 2024. It has taken considerable hard work and dedication to get to this point today. Each year, the plan has sought to respond positively to changes in national policy, guidance, and housing needs. Arguably, Our biggest challenge, however, was to come through our own evidence. In early 2022, surveys informing the Habitats Regulations Assessment identified that existing recreational pressures were resulting in harm to the integrity of the Chiltern Beechwoods Special Area of Conservation at Ashridge Common and Woods. As a result, the Council was unable to grant permission for a single dwelling anywhere in the borough between March and November 2022. A mitigation strategy was developed in collaboration with neighbouring authorities and in line with the advice of Natural England, following which the Council could start to allow some applications for housing to be determined positively. In this particular context, it is therefore an incredible achievement of the Council and the team supporting the preparation of the plan that 2 years on, the Council gave its approval to finalise a local plan that seeks a step change in housing delivery and growth for the area. It more than doubles the annual housing requirement from that of the previously adopted core strategy, 430 dwellings per annum. In addition to this, the plan responds to the Council's corporate plan to 2028 and to the many local issues through its spatial strategy, such issues being defined by their respective chapters in the plan: housing, economy, climate change, the natural environment, historic environment, design, transport and connectivity, healthy communities, and infrastructure delivery. As a whole, the plan is able to deliver on the growth in homes and infrastructure that our communities so clearly need, whilst managing to also ensure that development is sustainable and that we continue to protect our designated landscape, protected habitats, and greenbelt land. The Council has worked closely with our neighbours in South West Hertfordshire on housing and employment needs. Our joint evidence responds to a number of challenges, including planning for an ageing population, delivering housing that is genuinely affordable, and responding to the impacts of the COVID pandemic. For example, it sets safeguards for the most important employment sites and highest quality office floor space. Working with St Albans specifically, significant new employment land is proposed on the edge of Hemel Hempstead through the St Albans Local Plan to 2041, where demand is evidenced to be at its greatest. This work, which forms part of a shared vision for Hemel Garden communities, is one of the many examples of effective engagement resulting in outcomes with our neighbours. All growth needs the right infrastructure to enable it. The Dacorum Local Plan is supported by a comprehensive infrastructure delivery plan showing how and when such infrastructure will be delivered. In conclusion, Dacorum Borough Council is pleased to be here today and to be given the opportunity to discuss matters raised by the inspectors and others to our emerging local plan. To do this, my staff, Claire Covington, Keely Mitchell, and John Chapman, are here to lead on matters on behalf of the Council. Other officers and consultants will be available as and when to assist at the hearing. We are also supported here by Craig Howell-Williams and Mara Golden, who are here to help us as and when necessary on any legal issues as they might arise. Thank you very much.
Okay, thank you. Can I ask that that's added to the examination website, please? Okay, we'll get straight into the first issue then. As I said, we'll work through the matters, issues and questions document. If people don't have a copy, it is available on the examination website, and there may be some copies that Louise has printed off. So again, if you don't have a copy, grab Louise during one of the breaks. So we'll work through this morning some of the matters around legal compliance. Whether or not we get through all of them before lunch, we don't know, but we've got all day. And then this afternoon, we're talking about the housing requirement, which isn't a full afternoon session, so we've got plenty of time. So issue one, duty to cooperate. So the first question really is a bit of an opener, and it's a bit of an introduction. And the answer to it with duty to cooperate really lies in the detail. Now, there's two areas I want to spend a bit of time this morning going through. One is highways, and the second is housing. So they're the sort of two main issues that I want to look at. So question one really, question one is the whole topic, so we'll answer it as we go through. So two issues, highways and housing. So we'll start with highways. Now, Where I'm talking about highways, we are principally looking at your engagement with national highways. And a lot of this examination is going to talk about engagement with national highways, and it's going to talk about the M1, it's going to talk about Junction 8 a lot. So there's a bit of a spoiler there. Mr. Britton and I read National Highways hearing statement, and one thing that jumps out, and as a way of introduction, and ask the council to sort of take us through this, one thing that jumps out is National Highways in their hearing statement states, National Highways notes that although initial discussions during Regulation 18 and 19 between National Highways and Dacorum Borough Council were not as effective in the beginning, since submission, both parties have proactively increased positive engagement towards a tangible outcome for the plan. Now, the concern that we have, and what we want to explore a little bit this morning, is, and other people have made this in the representations around other matters, but is the issue around the duty to cooperate is about plan preparation. We all know that it ends upon submission. And it's been suggested by others that you engage with National Highways, that engagement was going on, and then there was a flurry of activity and a rush to get the plan submitted, and the plan went in, and you didn't actually demonstrate effective ongoing engagement with National Highways. So by way of an introduction, and to help Mr. Bristol and I, could you take us through what, how, where and when you engage with National Highways on strategic cross-boundary matters, and I think principally here we're talking about, you know, strategic impacts on the M1. How did you engage with them up to the point of submission, and can you point to any tangible outcomes to substantiate that that engagement was effective? So something you can point to say, yeah, we engaged and this was an effective outcome.
Thank you, sir. So with regards to just where it's spelled out initially, I think just going back to our statement of compliance, CD 13.1, matter 3 within that discusses the strategic highways and sustainable transport, and talks particularly about, you know, how we've engaged with various bodies on this matter. Within that, national highways are listed. Table 5.3 presents some of the engagement, or how the types of meetings and the engagement that have taken place, as well as the frequency of those. With that, you will see within there, we have within that list, meetings and correspondence relating to transport matters for the Hemel Garden Communities Programme, to which National Highways are listed on that. As you'll be aware, sir, that significant engagement has taken place through the Hemel Garden Communities Programme from the outset in 2019, when it was granted and was successful in its bid to join the Garden Communities Programme. Following on from that, we're conscious that, you know, the questions you've made with regards to the evidence available, I will note in our statement in response to this particular question, that we included some appendices of more meetings that have taken, you know, providing another level of detail about what meetings take place and when. And you will see within our hearing statement on that matter that, I think it's Appendix D, that we had listed quite a number of meetings that have taken place throughout. And it was important that of particular note is we do have a Hemel Garden Communities Transport subgroup that works with St. Albans, works with the County Council, but also includes representatives from National Highways as part of those meetings. And that's part of a collaboration agreement that we have in place with those parties, and I've been working collaboratively on that. As part of the Hemel Garden Communities Programme and the Transport subgroup, it's natural that we're discussing strategic matters, including the impacts of growth on the strategic matter network, or strategic highway network. And I think in terms of, you know, more clearly, going to the point of how do we engage up to the point of submission, well, I think some kind of elements I would probably note that are seen as positive. We did produce strategic transport modelling through the comment run. That's included in our evidence. And we did that for Regulation 19. That set out 3 transport model runs. that was consulted at the Reg 19 stage. National Highways, in response to that, sought more information in terms of evidence to deal satisfy with their concerns. In direct response to those issues that they raised and concerns that they had raised, we undertook additional transport modelling work, which again was accompanied the submission of the local plan. Now, just to note that transport modelling work is quite a lengthy technical exercise and can take many, many months to do. And I think it was a really good achievement that we responded so positively to their particular concerns at the time to be able to turn around and produce evidence that we felt was sufficiently robust. They didn't substantially alter the plan in any way, but it satisfied the particular concerns of National Highways relating to transport safety and matters of highway delays. Unfortunately, I think the only thing I can say is, while we had that and it was available, there was insufficient time for National Highways to look at it at the time that we submitted the plan. And it's for that reason then that I would say that naturally we wanted to make sure that any concerns that they had at the point that we submitted were swiftly addressed. And for that reason, I would say that is where I would say that engagement today wasn't bad, but engagement significantly increased just to ensure that while we felt it was sufficient, they still stated there was still some technical details within the model itself. Not saying that the evidence was wrong, that they just wanted to have some clarity and some comfort that it satisfied their concerns. That is the additional engagement that we've taken place. Many of these meetings, again, have taken place in collaboration with St. Albans as well, and with the County Council there. And just to say that, I would probably say that the fact that we have 4 duty to cooperate bodies sitting around tables, engaging on these matters is probably a testament to probably the work we're constructively doing in responding to these issues. I hope that addresses that question.
So yeah, just a couple of follow-up points then. So in terms of the additional evidence, I think you're referring to and again, correct me if I'm wrong, so it's the traffic modelling addendum, which is TRA 04. So that was produced in March 25, yeah. So when did you submit the plan, remind me?
It was in March 2025.
In March 25. So if you produced this in March 25, presumably you sent it to National Highways?
We did.
Your ongoing engagement. So the criticism arises from representatives that you've produced this work, which is important. You wouldn't have done it if it wasn't. You produce this work, which is important. You send it off to National Highways, and then you just put your plan in. How would you sort of respond to those criticisms that that's not in the spirit of active, effective, and ongoing engagement? You did this evidence, and there's been a suggestion that then there was a sort of quick scramble to get the plan submitted, and any sort of meaningful outcomes with National Highways have then had to come after submission of the plan. Why do you not play National Highways? Why do you not engage in your plans?
Okay, thank you. I think in the first instance, we were comfortable in our own mind with our expert transport consultants, WSP, and with the view of the County Council also, that the evidence was sufficiently robust to satisfy the requests of National Highways. In light of that feedback, in light of those discussions, we felt it was sufficient that we had enough evidence on that. With regards to whether we would wait for their response, I would say, in my view, it's important to note that everything that is happening with regards to Hemlock Garden communities, it's important to the plans, absolutely. But note that the engagement is ongoing, and looking at the frequency of meetings we have with National Highways, with St. Albans and with the County Council, they continue to take place long after this plan has been submitted. There was a meeting on Monday, there was a meeting 2 weeks ago. These continue to take place. Strategic transport issues is complex, especially with something as important as the M1, and particularly the safety of the M1. We want to make sure we get this right. I think from my perspective, with regards to growth, the concerns relate to the cumulative effect of both plans as well, so we need to consider that. And this takes time, and naturally, there's growth is not just here and in St. Albans, it's across the county, and it's more strategically beyond Hertfordshire too, in terms of the impacts on the M1. The detail itself, as I said, going back to the initial point, we felt was sufficient in light of our expert consultants' views and the views of the County Council in particular, who we were very much kind of guided by and supported with saying, what do we need to do to address these concerns? And we worked collaboratively to say that that study is sufficient to address those concerns. And it is. I think the matter of the outcome is that that evidence is what is ultimately now resulted in the view from National Highways that their concerns are addressed.
So if we fast forward a little bit, post submission, you've done some further highways work, and you know we'll come on to talk about that in future sessions. But for the context of this, it's important. So you did some work in March. You thought that that work was good. It was robust. And so then off the back of that, you've not waited for National Highways to respond. You've submitted your plan. You're happy that the evidence base is proportionate, adequate and robust. What then is the work that you've done off the back of that, which we received in May, June time? What's that then?
Thank you, sir. So when we submitted the plan, we had to ensure that our plan was sound. And for that, we have to understand our growth and the impacts of our growth on the network. That's the first test. We can't assume other plans will automatically proceed and be adopted. And I think what we have to recognise is, as you say, a complex examination, because we have an additional session, which is a joint session with with St. Albans, discussing Hemel Garden communities and what it means in terms of perhaps cumulative growth. So in terms of the plan, and its growth, we had enough evidence, in our view, that said that's sufficiently proportionate to say that this plan is sound and it's robust and meets the tests. The additional evidence is very much considering the two plans more in tandem and having a greater understanding of, well, if these two plans were to be adopted, as they were submitted, what would that mean in terms of the infrastructure requirements, the trigger levels? What would that mean in terms of Junction 8? Would we need to change anything within our infrastructure delivery plans as submitted? So it is an additional kind of comfort to ourselves and hopefully to you inspectors as well, that going beyond the examination of our plan alone, it's understanding, do we have sufficient comfort and clarity that both plans can be adopted with the right level of infrastructure being delivered at the right time, having regard to, the timing and delivery of sites, both within Hemel Hempstead in Dacorum and the edge of Hemel Hempstead in St. Albans. So it's kind of going another extra step, not necessarily a step of soundness for our plan, taken in isolation. It's understanding a little bit more, can we give more clarity on trigger points on what infrastructure is needed and when?
So you referred extensively in your hearing statement and this morning to this sort of long list of meetings that have taken place. So presumably those meetings around the Hemel Garden communities, presumably St. Albans were around the table, National Highways were around the table, county councils were around the table. So did you not at any stage during those meetings ask the question around cumulative impacts? You did. So why then does the evidence appear in May, June 25 post submission of the plan?
Thank you, sir. A very clear reminder of my discussions were that particularly the request from National Highways is their approach to every local plan is the same. They want to understand the impacts of each plan in isolation first. And that is what they will ultimately be responding to as part of the local plan process. I think it's in light of that we were very clear that we had to satisfy some requests first. Now, that's not to say we weren't considering cumulative growth. We have to recognise that a strategic transport model does to some extent take account of cumulative growth. But I think it would be a little bit unfair on Dacorum to be presenting information on submission that takes account of the many thousands of homes planned within the St. Albans plan, and what that means in terms of our impacts and what we need to do within our plan and our infrastructure delivery plan. There is a process here, and going back to one of my earlier points, transport evidence takes a lot of time. There has been evidence that has been worked up over time, and I note that there is a more detailed parametrics model that work has been ongoing with by the partnership, Hemel Garden Communities partnership, that has kind of looked at the more detailed impacts of growth from the Hemel Garden Communities area, which again takes account of growth to the north and to the east within both plans. I think for the purposes of plan making, County Council have always advised and continue to advise that it's the strategic model that's proportionately correct for determining the impacts on the network for the local plan.
Thank you. And you're meeting us too, I suppose, for the first time. Just to put a bit of I quite like the detail. Mr. Birkinshaw is more often more focused on the strategic things. You mentioned, just with that in mind, you mentioned two documents in particular: your duty to cooperate statement, which is CD 13.1, and you have Appendix C to your hearing statement. And the first one, the duty to cooperate statement at table 5.3, sets out the regularity of meetings that have been had on certain matters, and you pointed to those being particularly relevant to the strategic road network. And then you've got Appendix C of your hearing statement, which gives a bit more detail, the details and timings of discussions. I'm on about page 264 of the digital version. Just squaring the circle with what Mr. Birkinshaw has asked you, is there any detail beneath that in terms of the substance of the matters that were discussed at those meetings? I mean, from my reading of it, that shows when things occurred, but it doesn't necessarily detail what was discussed.
Yes, in short, there are notes, minutes, and agendas for each of those meetings, I think. And as I said, one of the key points we've had about this is engagement has to be demonstrated really from 2017, and we've tried our best to not overload users and anyone else with something that could be unwieldy and overwhelming. There are minutes, there's documented minutes for all of those meetings, and these matters are discussed quite, well, I would say more than frequently, and indeed, I would say they are held fortnightly. We can provide examples. It's a question of if you felt there was a need for more examples. We've tried to produce some examples of engagement. I think we always just like to treat things in the manner of, well, naturally they discuss evidence, both, emerging as well as adopted, and we have to treat that with the respect I think it deserves. That we want to be able to discuss things and issues as they evolve, and it's at a point in time. I would always maintain that the kind of best and most effective demonstration of engagement is the fact that these bodies ask us to produce evidence, and we produce the evidence, and they look at the evidence and they say they're happy with it. And but I see your point on that.
And just on that, if you could possibly bring me up to speed with the latest position with National Highways, as I have it from their hearing statement, and I'm looking under question 1, which we're on. They say, whilst in isolation, the impacts of Dacorum local plan have been accepted by National Highways, it's agreed by all parties that additional work to support the ongoing development of Hemel Garden communities is required. So is that's their position? Is it that in terms of the Dacorum plan, in the context in which you've explained it, okay, in the broader context, there is still more work going on?
Just to confirm, yes.
So it may help for your note that there's, of course, the statement of common ground with National Highways. I think it's ED 31.
I think we've certainly got details of, you've set out all the meetings, and clearly there's a lot going on. Just open the plan, your plan at page 23. Talks about partnership working, since receiving Garden Town status, the partners, and that includes yourselves, St Albans City and District Council, Hertfordshire County Council, etc. Clearly things have been going on. Engagement has been happening. I think for Mr. Bristol and I, what we're after is, yes, this is your plan, and yes, you've considered the impacts of your plan. However, you've been working, your plan says it, you've been working collaboratively. What I think we don't have, and what I think you may need to go away and just have a look at, is we don't have any evidence, I think, that shows how that partnership working has looked at strategic, cumulative highways impacts. Now it may well be, and obviously this work has appeared, so you know it's fairly obvious that there must have been a discussion because there's been an output of this work. And as you said, you know, you prepared your plan and you thought your evidence was robust. I think where we have some unanswered questions is the sort of evidential basis to say, well, yes, we have considered this cumulatively. We have looked at this, you know, as paragraph 2.14 says. We need the evidence to substantiate your paragraph 2.14 is where I'm going with it. You know, that talks about partnership working, a joint approach, collaboration, fine. Show us where that exists in terms of strategic highways matters. Obviously, you know, these parties were around the table. And it goes back to the point Mr. Bristow makes, is that it, you know, and as I said at the start of this, and I think it's in some of the questions, it's about tangible outcomes. It's not just a tick list of, we met our neighbours every week for 2 years. So what? What did you agree? What did you do? What was the effective engagement? Can you point to something that shows us how you effectively engaged on that issue? That's what we're after. So I think it's probably, you know, to look at it, it sounds like that has taken place. We just need that evidential basis. And I think listing the minutes, you know, we don't need to see minutes of every single meeting. It can just be some bullet points and some headline figures, but we just need something a bit more that really sort of makes the point clear that, yes, we did consider this. We were satisfied that our plan was sound upon submission. And you know, let's be fair, there's lots of plans up and down the country where, yes, we're entirely aware that, you know, matters go beyond submission. You know, there's no plan where myself and my colleagues are saying every single thing needs to be absolutely perfect upon submission. We completely recognise that. I think where we are just a little bit unsure is where the evidence shows us that you've actively engaged on the strategic cross-boundary matter of, you know, significant growth through the Helmand Garden communities and its impact on the strategic highways network. Does that make sense?
Yeah, we'll take that away. Just keeping in mind that we are looking towards Helmand Garden communities and sessions in October. I'm just wondering if it is helpful that we work towards that as a point to probably, well, to produce evidence.
No, we need that far sooner than that.
That's fine.
Yeah.
No problem.
And we need that, and we need to take a view on that, essentially. But like I said, it sounds like it's been happening. We just need that actual sort of evidential basis to show us, to say this is what we were doing. There was a hand up and it went down. No, I'm making that up. Okay, Mr. Churchill.
Yeah, sorry, sirs. I don't know exactly how to address you. It's normally sir or madam, but if we go with sirs, is that okay? I obviously saw reference in the National Highways hearing statement to a statement of common ground, and that's been referenced, BD 31, I think it is. I may be missing something, but I can't see, or I haven't been able to find that document in the examination library.
I believe it is added, and I think just a point of clarity, because some people do find maybe the layout of the website confusing. We do have the examination library, which is the library that takes us up to the submission of the plan. And then we do have a separate page of the examination documents, which are documents that were submitted. Well, the documents that have been published since we submitted the plan. So there's two separate websites.
Okay, anything else on strategic highway matters? As I said, that sort of probably neatly brings it to sort of conclusion, really. You know, it's about that evidential evidence to demonstrate, rather than just a sort of list of meetings, to demonstrate, yes, this is clearly an ongoing matter that we've been engaged with, and you know, we consider that this ultimately demonstrates that we believe that we have met the duty to cooperate. And yes, things have progressed post-submission, as you explained, but that's around and this is where there's two issues there. It does get a little bit confusing around legal compliance. Have you engaged actively with your neighbours? And a matter of soundness, is what you've done sound? And the two sort of stray into each other. And I think, Mr. Bristol and I understand what the council's saying. We just need a bit more sort of meats on those bones around the strategic highways matters. Happy to move on? Yep. Okay, well, that was sort of really questions 2 and 3 sort of combined. What I want to look at now is, as I said, there's two main issues really around duty to cooperate, was around highways and housing. Do people want to have a quick break before we go into housing? Should we do that? Just mindful that that's probably going to be, a good sort of 45 minutes at least. So mindful that it'll go on. So should we have a quick break now until 10 past? Is that okay? Yeah. Okay. We'll take an adjournment and we'll resume at 10 past, please. Okay, thank you everyone. We'll resume and continue. Just a housekeeping matter. Do I need to do anything about the live stream? Is that just carry on? So after adjournments, we don't need to do anything? No? Excellent. We'll carry on. We're going to move on to housing, but before we do, did anybody have any representations about other prescribed bodies under the duty to cooperate? So Ms. Britton and I have talked about national highways, essentially in some of the strategic cross-boundary highways matters. But did anybody want to make any representations about other prescribed bodies? I said we have seen representations. We've seen some of the concerns around infrastructure provision, healthcare, education, and a lot of that is the detail we'll probably come on to talk about in the slides. But in terms of the duty to cooperate, did anybody want to raise any questions or observations at this stage? No? Okay. Again, I've got the written submissions on that as well. So, housing and how the council approached the issue of housing need. So this takes us really on to, again, for those following the MQs, we're really into sort of questions 6, 7, 8, really. So this is sort of the crux of the matter. What I want to understand, and this is a point that's been made in the representations, is about the issue around your housing requirements and housing needs. So for those following the examination, I'll sort of give a bit of an overview. This is all on the examination website. So when we examine plans, it's not just the hearings. The examination starts from the minute we pick up the plans. Any initial questions that we have for the council is all part of the examination process. Now, we asked some questions of the council to start with around the plan period and the housing requirements. And the council has come back and said, yep, there needs to be some main modifications to the plan, and that's what we're going to talk about this afternoon, principally. Turning to the question of the duty to cooperate and engaging with your neighbours, could I just start by asking the council, how did the council approach discussions with neighbouring authorities? And you could almost really go right back to the start of the process. How did the council approach those discussions with its neighbours around whether or not this plan was meeting needs and whether or not its neighbours could help if required to meet needs? So just take me right back to the start. How you prepared the plan, what discussions you had with your neighbours, whether or not you spoke to them, whether or not you engaged them on this issue of whether or not anybody else could meet your housing needs if you so needed them to do so.
Okay, thank you. So, as I said, it has been a long process so far, 7 years between the start of the plan and Reg 19 in particular, and obviously we're here today as well. It has evolved over time, and discussions have been ongoing. And I'd like to, again, without kind of reiterating, going back to our evidence with regards to statement of compliance, our response to these particular questions and the appendices in terms of the list of meetings, which again is there to give a flavour, essence of the significant engagement that's taken place. We worked back in 2017. That very much was informed by an emerging standard method, a new process that set a new requirement that ultimately triggered the need to look at the plan from the outset afresh. That was worked up with our neighbours. We presented and discussed issues and options with that, and then that was consulted on and with our neighbours too. And at that time, we had been in place a number of duty to cooperate, probably specific meetings or things that might have evolved from the process. Particular reference within in Appendix D2, I think this was Hert's duty to cooperate meetings. They've been ongoing for quite a number of years now. The Hertfordshire Planners Group, Development Plans, is a specific group of planners across Hertfordshire. Again, those minutes are minuted, and we have notes of those stretching back many, many months and years. And we have other meetings as well, which can be a bit more bespoke, and they take place as and when we feel it's necessary. So we do have examples of specific meetings with St Albans, with Buckinghamshire Council, with Central Beds, and indeed with Buckinghamshire with its predecessors before it became unitary. Naturally, as we move and evolve the plan forward from issues and options, we were heading towards a full draft plan we wanted consulted on in 2020. And with that, we asked the question of our neighbours in 2020, as we set out in our evidence, that we asked our neighbours whether or not they could accommodate any of our needs. And that was part of the framework's requirement to consider engaging with our neighbours, speaking with our neighbours, seeing what they can do to help us. Particularly in relation to the Greenbelt, but obviously recognising there's other constraints or protected areas as well, notably the Chiltern National Landscape. The feedback from that, as we've set out in our most recent evidence, has demonstrated that, you know, basically they're all saying they're in a similar position to us. They have Greenbelt too, they are constrained, and some of them saying they're equally kind of struggling to meet our needs. And right now, thank you, but unfortunately, we can't help you. I've been in planning examinations for 15 years, and it's my third one, and ultimately I know these letters and I know the responses, and dare I say, I'd probably put it in this is a standard response, and we are all kind of, you know, trying to work together to firstly try and meet our needs. And that is what happened in the emerging strategy for growth and consultation in 2020, with a draft plan that at the time sought to meet the needs, that included looking at releasing land from the Greenbelt, and that took account of that engagement in that particular letter. From then, we moved forward to taking account of the feedback of that. I would note, just being clear on that was in the context of a government consultation on what they call the mutant algorithm standard method. And what the plan was trying to do was respond positively to the emerging position in national policy and guidance around needs.
Sorry, can I just just pause there, if you may? I'm just keeping up with the documents, and I think the reference you just made is to the letter that we referred to, asking in the eventuality that the council is unable to meet its needs, can neighbouring authorities help? And we've got the responses to that, 19th of May 2020. Now, you mentioned something, and I wasn't quite there with you. You said something like, this is a standard response. Can you just talk me through that?
I think it's probably my way of probably saying that every authority and area feels they're in a very similar position. London Metropolitan Greenbelt, everyone is trying their best to meet their own needs, struggling to look at it within without looking towards the Greenbelt. And I think, as I said, there was one or two examples even in 2020 where some of our neighbours sent us a very, very similar requirement as well, you know, a request to us. And that is probably an example of, can you take some of ours? Can we take, you know, and we're asking them and they're asking us. So we're all finding ourselves in a very standard position all around, where each one of us is kind of going, we'd like to be able to help, we haven't seen your evidence, you know, we need to look at that right now, you know, we're struggling to identify sufficient land to meet our own needs. Please come back. And we've kept that is generally seen as the starting point of that kind of trigger of engaging with our neighbours on a particular matter of releasing land from the Greenbelt. That then kind of forms part of a constant review or a review as and when necessary with our neighbours through formal meetings and or other formal duty to cooperate processes, as well as formal consultation. So just moving forward to the emerging strategy for growth in 2020, I think that was 922 dwellings per annum was the figure I think we were trying to meet at the time, based on government's draft new standard method at the time, which they then reverted back. So following consultation, we knew that we probably had to look again. And I think what happened after that is we have Natural England just coming in and saying you need to do a bit more evidence on habitats due to the cooperate matter. You need to do some evidence for your habitats regulations assessment to inform that around recreational pressure in particular. And we did that, and that ultimately resulted in a position that meant we had the moratorium, as set out in well, I'd say the moratorium. It's a period of time where we weren't able to allow any permissions to come forward for any housing in the area, and that was 2022. So a lot of evidence informing that, but ultimately we didn't want to say too much about a plan until we understood the evidence and what mitigation was needed, because it would be probably not prudent of us or wise of us to jump forward towards filing as a plan without understanding what mitigation was necessary. So we had the discussions, and with that, In 2022, we have the mitigation strategy, and in late 2023 then, you'll see as a timeline, we start ramping up work again on our local plan. And with that, it was a consultation on a lower requirement, we would say. Basically, we weren't able to meet our needs at that time. It was a focused consultation on changes to the strategy. It is taken in the context of, again, a government consultation around changes in particular to how plans should be approached in light of the Greenbelt and needs. Again, this was consulted on that basis where there was a tonal feel emerging from government that they were wanting to amend plans to give plans more flexibility about housing need, but we still took that in the context of it's emerging, it's not finalised. Importantly for us, we were very much kind of looking at consulting at that time on a lower requirement on the basis that we didn't have sufficient mitigation available and knowledgeably at the time to be able to say we could accommodate any more housing. And by mitigation, I mean back to the Habitats Regulations assessment. And being a legal requirements day, we professionally cannot recommend or finalise a plan without sufficient certainty that mitigation can be secured. So we didn't want to be putting it out there to the public, putting it out there to site promoters, to others, that we have all the answers for this and they're coming. We wanted to say, this is the best that we can do at this time. Here's a call for sites. Here's a call, we're looking for SAG, suitable alternative natural green space. And this was the position we provided with our neighbouring authorities. And I think it's very important kind of going back and looking at our most recent statements about what they said at that time of our 2023 consultation. They were very clear that we were not meeting our needs or not seeking to meet our needs through that strategy. But I think it had to be taken as that is what we felt we could deliver at the time. And if we did not have any further mitigation or any further elements, we would at least have the evidence to demonstrate that we have consulted on this strategy that reflects a more constrained approach to housing delivery. Subsequent to that consultation, we obviously got some positive responses. People started, in terms of housing delivery, looking up and saying, we believe we can get more solutions, and more solutions came our way following consultation. And for that, then the direction of travel in 2024 was, in speaking to our neighbours and in the meetings, is that we believe we can meet our needs. And that is our approach. And that message has not changed to this day in speaking with our neighbours. And we've never asked our neighbours in light of that. They said, we want to meet 1,016 dwellings per annum. We are not looking to our neighbours to meet any of our needs. We recognise that government is changing its approach. There's a new government, a new NPPF in December, and leading up to submission, the message was the same. So we were never expecting, or had been expecting, or anywhere within our strategy that we would be looking to any of our neighbours to accommodate our housing needs. Recognising we're trying to be clear on other matters, the St. Albans plan dealing with some of our employment needs and other matters like that. But that has been the approach to date. That's been the narrative. I think the neighbouring authorities understood our position, and I think they understood how the plan has evolved quite clearly on this matter. I hope that's a helpful context setter for you.
It is, thank you. And I think where we're going with this question and the sort of subsequent one is, if you fast forward to the situation where you've submitted a plan. So you've submitted a plan which you accept is unsound because there needs to be a change to the housing requirement. We're going to talk about that this afternoon. The criticism, and we'll open up to discussion, the criticism has been levied that you were preparing this plan in the context of we are meeting housing needs. As you've just said there, you've sort of gone through these various stages and you got to a situation where you're preparing a plan, you're meeting housing needs, but actually you're not. I think the criticism has been levied that you were approaching those duties to cooperate meetings and discussions on the sort of false premise that you were meeting housing needs when it's now transpired that you're not. Do you want to sort of respond to those criticisms before I open it up, and why you think that still means that you meet the duty to cooperate? So why do you think that actually yes, we'll come on to talk about the soundness, and we'll come on to talk about the housing requirement as a soundness test, but why you think for this session, you've done enough to meet the duty to cooperate in the legal compliance test?
Okay, thank you. So I think on this particular point, I'll probably say I've got probably 3 points in response to this. I think the first one is about how and when, and it's about the test, the legal test. I think it's about demonstrating constructive, active, and ongoing engagement. So it's about how and when. We have, we're cross-referring back to our statement of compliance, CD 13.1, and the meetings as presented within that, and expanded upon again by Appendix D in the Council's response to these Matter 1 MIQs. Local plan updates are a regular part of many, many meetings. So we've always engaged with our neighbours on this, and just giving a snippet of that, going back to the Hemel Garden Communities meetings, just in terms of evidence, we've with St. Albans, or Hertfordshire County Council and National Highways. The South West Hertfordshire duty to cooperate meetings we have quarterly. They're ones that I personally chair and lead on. It's something that I've been doing that for a couple of years now, and quite happy and comfortable to do that. It's we have to take responsibilities, and I'm a big advocate of the duty. The Hertfordshire Planners Group, development plans. All of these meetings include local plan updates from every authority. Hertfordshire County Council, albeit minerals and waste as well. They want to understand where our growth is going and the sites and what our plan is as we finalise. And then we have duty to cooperate meetings with Buckinghamshire Council and Central Beds. Now, again, going back to the point of habits rights, we have a lot and have had a lot of meetings around that. And we don't feel we need to have more bespoke meetings. We tend to bolt on, let's talk about our local plans at the end of these meetings and use that. So there's a massive frequency of meetings we have with our neighbours. And the vast majority of those have minutes and documented evidence. The what element, what are we discussing? The strategic issue. This is a strategic issue, it's housing needs. And we discussed that with all our neighbouring authorities throughout the preparation, as I've set out a little earlier. This included the identifying the local housing need with regard to applicable plan periods. We would discuss that. It is only on how we would do that. And the key message here is that the council was seeking to meet its own needs and not looking to its neighbour. And that was our message to them. And we can have and have had discussions before submission and before Reg 19 on this particular point. I was doing so. We were doing that even when the figure was increased to 17,272. So when we submitted this plan, we were talking to them. We were still saying we believe this plan is sound in the context of the framework when read as a whole when we submitted this plan. So, with that, the message has been consistent throughout. And just cross-referring to matter 2, issue 1 and question 5, we've set our position with regards to housing supply relative to the housing requirement on this as well. So, we can obviously pick that up this afternoon as well. So, in terms of the legal duty, it's about how we're engaging. It's, from my experience in the past, it's not necessarily about agreeing, but we have statements of common ground from those authorities, all neighbouring authorities, in one single statement of common ground that says they feel the legal duty hasn't been met and that we have engaged constructively, actively on an ongoing basis. I, double checked with them with regards to the specific meeting that we discussed the revised position of the council. Again, noting that I had to just get comfort from them that they were happy that I was able to talk about something that, was discussed at that meeting, even though we don't have documented minutes. They were comfortable for me to include that within the statement in response to the MIQs.
From the council's position then, this is where it is a matter which does sort of stray into this afternoon really. Is it your position then that you have engaged with your neighbours on the process and the basis that you will be meeting your housing needs? And Mr. Britton and I have identified an issue with the housing requirement, and that your position is that you're saying, therefore, that that's a soundness matter, and that's a soundness matter that can be rectified in your view, and that's a debate for this afternoon and other sessions, that in your view, yes, the housing requirement figure in the plan is wrong and it needs to be changed, but, you know, for reasons X, Y, and Z, we'll come on to discuss that, you know, your position is we don't need any more housing sites, and people around the table say, well, of course you need more housing sites. So in terms of this session then, is your position that that doesn't demonstrate a duty to cooperate failing? We've had all these meetings, we've had all this engagement. It's a soundness matter that we're going to have to, over the course of the coming weeks, resolve through this examination process. Is that a sort of fair summary of the council's position?
I think the short answer to that is yes. And just in addition to that, I would, from my experience going back and looking at scenarios of unmet need, I've been directly involved in Oxfordshire was one, and Oxford City's unmet need with its neighbours. That example of the engagement to date and the discussions at that time, particularly when I was involved in the Vale of Whitehorse local plan, the fact that the outcome, the effective outcomes of engagement is evidence, and the policies within the plan, and that is reflected within strategic policies in the plan. And I would maintain that we do have a strategic policy on housing need. And even though all our neighbours are in agreement with us, you know, that is a matter of, well, what changes might need to be made to the strategic policy is more of a matter of soundness, I would maintain. I would just reiterate that the engagement has been long-standing over many years on this. And it's been, it's something I consider is in evidence terms is proportionate.
Thank you, sir. So, as you'll have seen from our hearing statement, excuse me, we raise 2 points on the duty to cooperate, 2 quite distinct points. One is about the sufficiency of evidence, and really what we're doing there is putting the local authority to proof. You know, at the point in time at which the hearing statement was drafted, there's quite a paucity of information. What we do is we just leave that in your collective capable hands, that point. I don't say any more about it. Recorded in our hearing statement 2.4, I won't repeat it. That's that one. Very short. The second is, takes a bit more to articulate, but you're already on that theme. And that is about whether or not there has been constructive and ongoing engagement. And the concern that arises is most acutely seen at a point in time, which is a really pivotal one in the process. We can see that the duty to cooperate statement of common ground with the local planning authorities was in, as you'd expect, in March, where you've got the submission of the plans. You've got the submission of the plan on the 11th of March, and you've got the local planning authority's statement of common ground, SG 01.1. You can see that the council's hearing statement for these hearing sessions relies on that statement of common ground in order to discharge the duty. And you can see that I don't take it to the reference, but I give it to you. It's 1.1.10. So that's in the council's hearing statement. So it's obvious that they are relying on that statement of common ground as at the March 2025 date. And just in terms of what was the sort of collective position at that point, this is a reference that I think it is worth going to if you're happy to. And this is CD 13.1, which you've already had up. And within it, in the housing bit, at page 17, what are the effective outcomes of engagement, which I know has been your theme, if I've correctly understood, and I think I have. So if you look at 5.12 on that, just pausing there, just to absorb that. So the spatial strategy to 2041 seeks to meet its identified needs in full within Dacorum for the planned period. And the footnote 6 explains that the period there in question was 26 to 41, and the need identified is 15332. So you can see that the position as at the date that the statements of common ground are, the statement of common ground is being signed, is a specific factual position, a plan period, and a specific identified housing need. Then we have your queries, the questions rather, and then the response. And the second reference again, which we do need to go to, I think, is ED3, which is the Council's response to the questions. And within ED3, when you've got it, page 4, thank you. Again, I'm sort of conscious I'm telling you things you already know, but just to set this out in a sort of methodical way, what we can see there is that we've shifted the plan period and the housing requirement. So the upshot is that we get a different base date and a different housing requirement. And with those changes, we see even on the council's own account, a shortfall, just assuming, taking trajectory and so on, completely at face value, we get a shortfall of 842 homes over the period, 842 homes over the period. So that's the detail. Just then reflecting on that, what does that mean? Well, the concern that we are raising is how, at that point in time at which the statement of common ground is signed, how is it that you can have a demonstration of constructive and ongoing engagement which is, if you like, effective, if that is wrongly based? And we have raised it as a concern in the representations as a legal compliance issue. We acknowledge that the process is an ongoing one, but there are clearly points in time which are particularly important junctures where you would be looking at whether, and it's appropriate to look at whether you can see a demonstration of compliance. It is a concern that there seems to have been an assumption that there was going to be no contribution by neighbours, because if you like, we're all in the same boat, so essentially we don't need to revisit that issue. Actually, the underlying facts should be important. If you've got a shortfall, you should be constructively engaging, in other words, identifying the correct factual position, and then inquiring and, if you like, diligently looking to see whether or not that can be addressed. The position then when we get the council's hearing statement is then, with respect, puzzling, because we're being told, for example, if you look at the hearing statement, and this is the final reference to which I'd like to draw your attention. So the hearing statement, and within it, page 21, once you're there.
For the council's hearing statement? Or,
that's it.
Yeah.
Council's hearing statement, yeah. question 7, do you see dealt with on page 21? So we've got your questions, which of course you know what they are. So question 7, how did the council engage with the neighbouring authorities prior to the submission of the plan? And this was on the base date point. Base date which you queried was set out in the submission plan. And the answer that you're being given at 1.7.2 is, well, the local authorities were briefed on this change prior to submission. They briefed on this expected change at a quarterly duty to cooperate meeting on 17th of January 2025. So that was prior to submission. We're a bit puzzled by that. So essentially there's two underlying concerns. Why is the plan being submitted in the way that it's being submitted if it was understood that there was a problem with it? And how can it be said that this was constructive and in turn effective if it was wrongly based? And there seems to have been some understanding of that. Now, it may be that we've misunderstood this, read too much into it, perhaps we'll be told if so. But on the face of it, it's confusing. Other than that, we rely on what we say in our hearing statement, and we wouldn't wish to rehearse all of that. But we would like to understand the point.
Just to go back to Mr. Leyland, then, could you just take us through that final point then? So this is really your answer to question 7 in the hearing statement, and it's the second paragraph, in particular about meetings held in January 2025. Could you just take us through those? And again, what was done? I think you said the sort of how, where, when, and etc. Just take us through exactly what that meeting was and the outcomes from it, please.
Yeah, no problem. So we completed our regulation 19 consultation at the very end of 2024. We were examining and analysing the key issues as part of the Reg 22 statement. With that, we identified this was something that was raised by a number of authorities, or a number of other representatives as something, and we reflected that appropriately in the key issues. So it's something we were mindful of. And we also accompanied that Reg 22 statement, for submission at least, with an officer response. And we basically said, you know, in light of the feedback on this issue, we feel that the plan needs to change in light of this. And that is the position we were at, and where I was at going into that meeting. It's one I attended, you know, on behalf of Dacorum. As I said, it's one that I chair. When going into the meeting on the 17th of January with those neighbouring authorities, said that meeting was also to discuss the statements of common ground, because that's an appropriate time to convene people and discuss that. And that was in good time before the statement of common ground was agreed. So, naturally speaking, I did not want to be in a position where I was not telling them about this issue as part of that process, because I recognise the importance of having a statement of common ground that's basically saying the duty has been met and that they have been aware. And they also are very clear in our position when we submit the plan, is that we still feel that the plan is sound insofar as it is meeting its needs in a manner that's consistent with the framework when read as a whole. So that particular point, I'd like to think is a timeline. You know, we did recognise it with the Reg 22 statement that this was a key issue, and we set out an officer response that we are going to make some changes. And we engaged with our neighbouring authorities through the duty to cooperate at one of our quarterly meetings. You know, they were aware of it. They were aware of the message, as I reiterate, as I said earlier, that we are trying to meet our own needs and we're not looking to them. That was our position on that, and that we weren't looking to them to accommodate any of our needs. For that reason, you know, I would say that in terms of how we've engaged and how we've discussed this matter, and again, as set out in more recent evidence in terms of ED3, you know, we feel that the plan is sound with regards to this, you know, but we appreciate that there, you know, if necessary, we think that modifications can be made in terms of a, you know, an early review or otherwise, if necessary to the soundness of the plan. But ultimately, we still feel this plan is still consistent with the framework when read as a whole with regard to housing needs.
So the meeting in 17th January 2025, how did you approach that then? Obviously, you wanted to inform your neighbours that yeah, off the back of the Reg 19, we think the plan's wrong, needs to change. How did you approach that? Were you approaching it along the basis of the housing requirement needs to change, we're going to be short of numbers, this is what we're going to do? What was that, this is what we're going to do? What was the actual outcome of that discussion? Obviously, you've briefed your neighbouring authorities that, yeah, we got this wrong, there's going to be a change. Fine. Yeah. What was the next stage of that discussion? What was the sort of the so what? What was the outcome of that? What did you agree that you would do going forward? Because obviously, fast forward to where we are now, the council's position is, well, the plan's unsound, there needs to be a main mod, and it goes back to what I said before, but we don't need any more housing sites. We've lost a couple of appeals and windfall will mop it up. That's the council's position. What did you do at that meeting then? How was that issue tackled at that meeting on the 17th of January? And importantly, where's that set out in the evidence?
So I think with regards to the discussion and how that was broached, I think we were of the view, and again, I'm trying my best not to straddle matters that might be more appropriately discussed this afternoon. We had, reviewed the key issue. I think one thing is we had to look at what our housing supply was as a result of that modification, and what that meant. And what it meant is that when on review and looking at the modifications to be made to the plan, we were of the view that A, we identified a specific amount of sites, deliverable sites, for the first 5 years in a manner that could identify and demonstrate a 5-year supply of housing. We were able to demonstrate that, developable sites as well for years 6 to 10, and that where possible, we identified sites for 11 plus, years 11 plus. And that as a whole, and looking at that, and particularly looking at the prevailing nature of government policy with regards to the December 2024 framework, what it was saying about Greybalt, what it was saying about other bits, and that while despite the position that we could still demonstrate a 5-year supply on adoption, taking account of what we would probably say is shortfalls from the 2 additional years, we still felt, on balance and as a whole, the plan was sound with regards to the framework as a whole. And that was the message that was relayed. And I would probably say that if we were not able to demonstrate some of those tests, we didn't have a deliverable supply, and we didn't have a 5-year supply on adoption, then maybe the conversation would have been different. But that wasn't the conversation that was had. And that was the position that was set out with the other authorities. I would probably personally just go back to meetings leading up to submission. I remember a particular meeting with Buckinghamshire Council where we had discussed this particular matter. They had indicated and seen from our papers that we weren't including the 2 years. So discussions were ongoing before this plan was finalised, and discussion was on. We just set out our approach quite clearly. This is our approach, and we're not looking to anyone to meet our needs, but this is the approach we intend to take for finalising this plan. And again, just to kind of go back to the core point on this, the legal test is about the engagement. It's about the engagement, the frequency. Have we discussed? Have we gone out? Have we set that we have spoken to our neighbours on these matters? I feel there's enough evidence there to say that we have, proportionately speaking. I'd say we do. And do I think that, our neighbours are comfortable with our position at this stage? I think, it's reflective of the statement of common ground, particularly with the South West Hearts authorities, which are part of our housing needs area, housing market area. And with our other neighbouring authorities who are at a very early stage of plan preparation and ultimately weren't in a position to say definitively that, they haven't even started their sites evidence work. They haven't, gotten that far yet. They weren't in a position to say themselves could they may take any of our needs. And that was the position that we had in discussion with them, that they weren't able to say, yes, you can take some of ours. We're just too early on in this process. And by that, I mean Central Bedfordshire and Buckinghamshire Council.
So is it documented anywhere where you set that out? So is it documented anywhere where you had those discussions at the January 25 meeting with your neighbours where it was cards on the table, yet we acknowledge the reps from the Reg 19, we were going to be short on numbers, but ... we think we're going to be okay because of all the reasons you just explained. So is that set out anywhere in the evidence?
It is not, and the reason for that, just being quite simple and clear, is for probably yeah, quite a number of years, that those particular meetings are subject to Chatham House rules, and for that it was an environment in place where we as officers can discuss matters freely with some confidence on that. I think hindsight's a great thing in terms of, you know, but I probably have done it in something more formally, knowing that these discussions might materialise, but I felt it wasn't a major issue at the time because, as I said, set out, you know, the council's still of the view and position that, you know, the plan as submitted is sound and consistent with the framework when read as a whole. And ultimately, it is probably a matter of proportionality here about something that many of the authorities probably would have perceived, and I don't want to put too many words, as being not much of an issue.
So the meeting of the 17th of January, there's nothing, then is there? There's no minutes, there's no agenda, so from our point of view, to try and help us with this then, we are in a situation where you're saying, it's fine, inspectors, we did engage with our neighbours on this issue, and it's quite an important issue because we've been consistently saying this is the planned period, we're going to meet housing needs. In fact, we're going further, and we'll have a bit of a buffer to fast forward to now actually, no, we're not meeting housing needs. Try and help us explain then how you actively engaged on that issue and how we can substantiate that in a report. Because at the minute, I completely get what you're saying. You're saying that we had these meetings, we've had loads of ongoing meetings, everybody knew the situation. We discussed it in January, and surprise, surprise, our neighbours were really happy when we didn't come and ask them for some housing, essentially. Where is that evidence? Where can we, in a reporting stage of this examination, pinpoint that and say, yeah, this was a live issue, it's a strategic cross-boundary matter, and the council engaged the neighbours on it?
I think my short answer to that is the statement of common ground. That is the one that basically says each of our neighbours have looked at us at the point of submitting the plan. It was produced and evidenced to be a march. And they say, in terms of the legal requirement, that they consider that we have met the duty, that we've engaged constructively, actively on an ongoing basis with regards to strategic cross-boundary matters. And there's that statement of common ground is with the South West Hertfordshire authorities, with Central Bedfordshire Authority, and with Buckinghamshire Council as well. So that, in my view, is always intended to be the purpose and nature of that, is that they have looked at us, they have spoken to us over the many, many, many years, and they agree with us that they feel we have demonstrated the legal duty has been met. That is the kind of core evidence with regards to this, and being mindful of the PPG and others say we do need to produce statements of common ground. It's short, it's to the point, it deals with this specific point of legal compliance, is whether the duty has been met. And again, having regard to that, in light of all of the engagement that has taken place, that is the position we're at. You know, a number of authorities have submitted representations, that's, you know, through the Reg 19 stage, not everyone. I think if there was an issue, I'm pretty sure some of them might have raised it if there was an issue or concern about this point. I think, you know, sometimes no evidence is evidence itself.
Just two comments, if I may. I won't repeat all that I've said, but I maintain it. On the statement of common ground, that is SGO 1.1. Looking at paragraph 7 and 8, it seems to relate to the plan as submitted. Whereas ED3 page 4, as you know, is pointing to what I understand to be a linked pair of changes. Which I think you're being told was understood in January of 25, prior to submission. And what I'm having difficulty with, and I invite you to grapple with, is that you seem to have two sort of narratives going on here, two sort of bases on which you could be undergoing constructive engagement so that it's effective. And they don't seem to be consistent. So query how that duty is met in those circumstances. And as I say, I completely acknowledge that it's an ongoing process and you have to look at all the evidence, but where you've got, you know, important junctures, you do, I think, have to consider them. So unless there's some other points arising from the hearing statements, that's really what I wanted to say about that.
How do you respond to the council's position has been, the 2 point actually. The first point is the council's position is we've been engaged with these neighbouring authorities for several years, we've had lots and lots of meetings and we've been, you know, we've heard about those. And essentially they're all constrained, they're all green belt, we've all got AOMB, National Landscape, etc. Therefore we were under a sort of agreed ongoing joint position that neighbouring authorities were not able to help us. Therefore, this issue's arisen and we've got a bit of a shortfall. We're not going to go back out and start formally writing to every single person, neighbouring authorities, to say, can you help us mop up this 800 dwellings? Because we've got a very good working relationship and we know exactly what they're going to say.
Completely understand from a human point of view, but from a proper process point of view, not appropriate. My concern would be that if you have assumptions like that, they may not be warranted, because when the facts change, conclusions may change. And so in order for you to have effective engagement, you've got to be operating on the correct factual premise.
So I wonder whether I might assist here, because I think we're just merging into an area of law and approach under the duty to cooperate. And as I understand your question, it's seeking at this stage at least to understand the duty to cooperate and how it has been met, as opposed to an issue of soundness. And so the approach here is quite important, indeed reflected in at least one of the authorities to which Ms. Murphy's clients refer in their witness statement. So I just wonder whether it would help just to make these points. The first point is that under the Act, the duty relates to strategic matters which might have a significant impact on another authority. Emphasize strategic matters which might have a significant impact on another authority. The second point is that the focus of the duty, the statutory duty, is a process one. It's a process one. And one can take from those 2 points this proposition that the duty, we know, is trite law to say it's not a duty to agree, nor is it a duty to consider a specific figure or fact. The obligation is to engage constructively, etc., on a strategic matter. In this case, housing needs. Strictly speaking, if the duty to cooperate body concludes that there will be no issue of unmet need, no need to look to its neighbours to meet any need, and the position is vice versa, then it may reasonably conclude that it's not actually a strategic matter that has a significant impact on the neighbouring authority. In this case, that is the position, as it happens, strictly speaking. The consensus is just that. And I'm aware of one report this year where a colleague of yours has made that express conclusion. It's the Wirral local plan. But even if it were to be concluded otherwise, in other words, that there is a duty which is engaged on the facts of this case, the Council's position, as has been emphasised by Mr. Leyden, is that there is a huge amount of evidence over the period to which you've made reference and which is covered in the various documentations, including the statement of compliance and so on, over a very long period. The focus now made on the change to a planned period and the alteration of a local housing need figure does not disrupt that effective ongoing discussion in the circumstances where not only did everybody agree that they were not looking to other authorities to meet that need, but in circumstances where the housing need was known and discussions were clearly also taking place on the question of planned periods. It's not a novel change in circumstance to that extent. And so there is no dual narrative here. There is no inconsistency. We invite you to conclude, for all the reasons given, that the duty to cooperate, insofar as it has to be met in relation to housing need, has been more than sufficiently met. Can I just ask you also just to bear in mind 2 or 3 matters of general approach here, and I know, and forgive me, they'll be well known to you. The first is that, of course, the question for you is, can you reasonably conclude that the duty to cooperate has been met? Can you reasonably conclude that? And we say, well, you can, more than reasonably. We suggest that you ought to on the evidence. When carrying out your task, you need to take into account following 2 or 3 matters. First, that the how, you remember Mr. Leyden said the question is how we met the duty. That question is for the local planning authority. It's a matter of judgment for them. So when exercising your planning judgment about whether or not the duty has been met, you have to bear in mind that it's for the local authority to determine how to do it. Your question relates to the question of, was a strategic matter the subject of engagement in an ongoing basis? The second point is that the judgment that they make has to be afforded what's called in case law a margin of appreciation. In other words, you have to, from your position, sir, move down and see from their perspective, bearing in mind in the first circumstances of this case, the consensus reached, the evaluative judgment they made about how to conduct those discussions was well within the margin of appreciation from their perspective. Indeed, it gains terrific strength in my submission that all the authorities were of the same view. The margin of appreciation goes further than that and extends to your task in a slightly different sense by reference to the evidence that you're wanting to see and that we've provided for you. As Mr. Leyden has said, the Council has sought to take a proportionate approach, but adding considerably in response to your MIQs in the hearing statement, extraordinary level of information about meetings on which you've heard further today. But on the specific point raised by Ms. Murphy and pursued in relation to what she calls, well, how can it be constructive if it was on the wrong basis? That does not take into account the proper remit and the proper role that you have, which is, has there been compliance with the duty which relates to a strategic matter? Not a specific figure, not the details of that discussion, especially in circumstances, as in this case, where in fact the consensus was related to housing needs, where there was complete agreement. I hope that's helpful. If there's anything further on those submissions, I'd be glad to assist further.
So just to summarise, and said this probably the break, is it your position then that this firmly lies in the territory of a soundness matter and one of housing requirement and whether or not the plan's going to meet its housing need and the sort of the detail of how it's going to do that rather than a fundamental lack of cooperation on a strategic cross-boundary matter?
Yeah, most definitely, with the only qualification with potentially a soundness matter.
Okay.
Hold
that thought.
That's not meant to be.
We'll go on to that this afternoon.
Okay.
Ms. Murphy.
Probably helpful to start with where we agree. We've set out the right approach in the hearing statement, and I know you know. So, but it's there as a reminder. So in terms of the legal principles, we don't disagree. So just 2 points, because I'm not going to repeat it all. Maintain it, don't repeat it. 2 points. One is it's been treated as a strategic cross-boundary matter up to and including January, March. So you will consider that carefully, I expect. And then secondly, I'm afraid the concern which has been outlined, I'm afraid in my submission doesn't find a satisfactory response in what's been said at all. So we leave that, just leave that with you.
See a couple of hands appear, so reading people's names and silence will get to know you all. Mr. Churchill.
Yes, thank you. We've obviously heard this morning and read in evidence that the council accepts local housing need means local planner submitted is unsound. Just picking up on previous points, and it's probably more a question 8 point, and in particular the response to the council in ED3 to question 8. It may just be me, but I must admit I am confused as to why, in accepting that the plan is unsound by virtue of not meeting local housing needs, it goes on in 1.8.1 to suggest that unmet housing needs are neither a soundness nor a legal compliance matter. I'm, with the greatest respect, baffled by that, and I think that's an untenable position to take, particularly when you consider what the MPPF requires in relation to cooperation, and in particular, paragraph 26, that requires specifically those joint working to help determine where additional infrastructure is necessary and whether development needs that cannot be met wholly within the plan area could be met elsewhere. I would suggest on the matter of unmet needs, they clearly cover a much wider area than just this local plan, and in that context are clearly strategic in nature. And just whilst we're on the MPPF, I'm just hearing what the council said in response to the previous matter, I'd suggest that paragraph 27 of the MPPF clearly doesn't support the Chatham House rules approach to meetings and recording of matters, where it clearly requires statements of common ground to be produced, to be kept updated, and specifically to be made publicly available throughout the plan-making process to provide transparency.
Thank you, sir. Mine's more of a point of clarity from Mr. Leyden, and it probably feeds into later on, so I apologise if this isn't quite the time. But it seems from his statement that the very early assumption that the council were going to meet all the needs, and so they weren't going to ask. And this was done at a really early stage, unless I've misunderstood it. So going forward, that feeds into their whole process and methodology going forward. They have a prescribed outcome, and that feeds into reports and things that are produced later. So I'd just like to clarify that, when exactly that seed change started, because I know when we did it from the core strategy, it wasn't their position. And then it is changed, and he said it many times that they went into all discussions saying that, don't worry, we're going to meet all our needs. Thank you.
Can I just clarify one point, presumably before we come to you, Mr. Leyden, on that? And this was one point I didn't understand from what you said. When that change occurred, now was that change you're referring to the change in we're going to meet needs in full versus we might not, depending on constraints? Or are you referring to the change in the time frame of the plan, this 2024, 2026 issue?
Well, it seems to me it's the attitude, the change. So it's before that they actually judge what land they've got and what is acceptable for development. So they change their issue, so they then inform, as the developers do, an outcome-led strategy to finding land.
So it's when, just so I'm clear on my mind, it's when the approach was taken that the council were determined to meet their needs through the plan. That's the question you're asking. Is it when that occurred?
Yes, I am. Regardless of the constraints, it's what they regardless of constraints, they're going to meet the need.
Thank you. Are you good to go to Mr. Leyden?
Thank you. Just probably turn to the last point made. I would say officers reasonably have to consider the NPPF and the requirements of the NPPF. Paragraph 11 is very clear that for plan making, or from the outset, we should, as a minimum, provide for the objectively assessed need and or seek to meet our needs. And that has been our position from the outset of plan making with this plan. It's in review of the constraints, and particularly those identified in the footnote, or the protected areas, may result in a lower figure. And I would say that, put forward that in 2023, with our revised strategy for growth, in the light of the narrative I presented around habitats regulations in particular, and maybe some of the narrative around changes to national policy, we were looking at a position where we were not at that time able to put forward a strategy that sought to meet our needs. And for that, but I still maintain that I think the golden thread all along from us in this plan is we have tried to meet our needs in full. We have sought to that, and we feel that the plan as submitted is doing that, insofar as, having regard to the framework as a whole. So the decision never really changed. The position of our recommendations and what this plan should include has always been in the context of that particular requirement of the framework that we should be seeking to meet our needs. And it, the evolution of this plan has not been a very simple and straightforward one. It's had to deal with a couple of bumps along the way, which have ultimately kind of resulted in different kind of revisions being made and tested and consulted on. But ultimately, we feel that, what we have in terms of submitted plan, meets the framework as a whole.
Thank you. And I know Mr. Harbridge didn't ask this, but I'm going to ask this. We're talking a lot about the change in time period, time span, whatever you want to call it, between 2024 and 2026. And as I understand it from the council's position, that was based on the assumption that the plan would be adopted in 2026 and therefore that would become the start date. Was that same theory, that same approach applied in the revised strategy for growth and the previous regulation 18? As in looking forward to when those strategies would be adopted and determining that that would be the start date? It's a mean question. Sorry about that, but no, thank you if you can provide any clarity on that.
I think in every situation our plan period changed. Is probably the first point. The start year and the end year changed. I think 2020 we had a 2020 start date with a 2036 end date. 2023, I think we looked at for the revised strategy for growth, it was 2024 to 2040. And I think in light of where we stood with the NPPF at the time, I think in particular, noting that, just being clear for, where we were obviously 2024 or 2026 to 2041 was 15 years on adoption in regard to, the NPPF on that. It's something that councils have to adapt to and change ultimately. And we've had 3 housing needs assessments, I think, or, the 2 really kind of fundamental bits of evidence there that kind of sets, and we had to reset the plan period dates accordingly. And yeah, I hope that's helpful.
That's helpful clarification. My other, in fact, my last question, which comes back to, I think, a second point that was raised by Mr. Churchill, perhaps. If there was this meeting on the 17th of January 2025 that's been the subject of much discussion. Just want to be absolutely clear what we're being asked to do. Given that it was Chatham House rules, is your position that there is nothing that is out there in terms of what was discussed at that meeting? And in the hypothetical situation we were to ask you if there was anything that you could give us, you would say no.
I think the short answer to that is no. I think if there's anything I could maybe consider as an option, it's whether a revision or an update to a statement of common ground with some of these authorities that might be able to spell out more clearly comfortability and not just reliance on something in my statement. But as I said, before including that particular reference to that particular meeting, I was naturally wanted to ensure there was some comfort from the South West Hertfordshire authorities. They are broadly comfortable, and they said they're broadly comfortable that it can be included, recognising there was no minutes. And I had to put my hand up and say, listen, I have nothing else to draw upon on that.
Okay, we'll move on, and we've sort of discussed this and sort of going around in circles. One question that I haven't turned to, which does sort of wrap up sort of the housing top of the duty to cooperate, was around the South West Herts Joint Strategic Plan. So could you, Council, just give me a bit of an update, background, context as to from your perspective what that is and why or how it was relevant for the purposes of the duty to cooperate? In terms of the South West Herts plan, just your position then on where that is from your perspective, and whether or not you think it's relevant to this topic of strategic housing matters under the duty to cooperate. So again, discussions that you've had, engagement that you've had as part of that process, and maybe if that process has sort of stopped and been overtaken by other events, etc.
Okay, thank you. The Joint Strategic Plan has been ongoing for quite a few years, and I know some representatives have, talked about it in different notes that, nothing should be deferred to the JSP. Some things are quite important for the JSP to deal with. It has always been considered from the outset that the JSP would look beyond the current plans in preparation. and that was always to consider that it is the next step, and it has been saying it will look to 2050, but it has to have some degree of what's happening right now with plans and how they're emerging. Now, most recently, obviously, there is the emergence of a new form of spatial development strategy, SDS. We feel and expect, obviously, there's a lot more in terms of guidance and more elements to emerge with regards to how they're going to be carried forward. But to all intents and purposes, I think the councils are working on the basis that work on the JSP is going to be taken over by the SDS. Now, there's been a lot of work done on it over the years. There's been, in terms of the engagement, it's again another very constructive form of engagement, very much Southwest Hertfordshire authorities. We do have, a joint team that is, expected to deliver this and has been looking to carry this forward. That is, that's in terms of the engagement and the meetings. We do meet, I think, once a month on that in terms of frequency. Informally, a number of the officers are actually in Dacorum. That's their kind of core base. So those that are directly kind of responsible for preparing that are basically sit alongside us. And many of our meetings and all of our meetings take place with the wider Southwest Arts authorities. It does very much in terms of it has regard to our evidence as emerging. We've got some very useful evidence that the needs assessments, the economic study, they're all covering the same geographic extent of that, and that's kind of part of their consideration. I think some of our evidence does look forward towards 2050 in terms of some of what it's kind of considering as well. So there is really kind of good alignment on that. Obviously, there is just, for right now, we just need to be mindful of what happens next. And I think we are expecting that it will come forward, as an SDS going forward. It's again subject to more clarity and guidance on that precise process. I hope that's helpful.
Thank you. Mr. Churchill, anything you want to add on that?
Yeah, sorry, it was in relation to the previous point and coming back to the 17th of January 2025. It was a plea more than anything. I've had the pleasure of being involved in the Horsham for quite some time in the examination of that local plan, where we had the examination effectively paused after the first round of sessions dealing with stage 1. That was in a similar duty to cooperate concerns about the availability and accessibility of evidence. We've since seen the council respond to that examination fairly recently to effectively say that they are willing to submit handwritten notes of meetings. In the context, and it's obviously a significant, important point, Mr. Leyden has said on a number of occasions that there is categorically nothing. I think it would be helpful if that could be a categoric nothing, not even handwritten notes. So nothing is available for that 17th of January, so we don't have a rerun of similar circumstances that those we faced in Horsham.
If we've covered that point. I did have another question in the duty to cooperate around employment and some of the employment matters. I've not seen a great deal of representations on that, other than to say from our position, which is a bit of a spoiler alert, I think there is a soundness matter there. I think there's a soundness matter about effectiveness and how clear and effective the plan is in addressing some of those issues. I don't wish to ask anyone, I don't have any further questions on the duty element of those discussions, unless anybody did and wanted to make reps on that particular issue. Yeah, Siegel.
Not to be flippant, but I would greatly concerned about the fact that the council have not actually approached directly with a direct question or request for support in providing the housing needs. And I say not to be flippant, but if they had actually done so and had a rejection to place before you, there would be very clear evidence that they had met the legal obligations. But I think what we don't understand is why they have not asked the question of the local authorities around the borough for help in meeting their need, given the constraints and the well-known constraints that exist in the borough to meet those housing needs. And I don't find the fact that they simply accepted that they will meet the need does not answer the question as to why they have not asked for help.
Did you want to add this? A topic we've sort of discussed and probably know the answer to, but did you want to add anything further on that?
Only just to refer back to the evidence I think we produced to date with regards to this in terms of the engagement. We did ask our neighbours, and we've kept that, and that was set out in the May 2020 letter. We've kept that process under review. But just referring back to the responses where we did receive them, our neighbours were very clear that at that time and subsequent to that, they basically said they were unable to accommodate our needs. Again, just to finalise and go back to the point that the starting point is in the framework is that we should be seeking to meet our own needs first, and we have to take that, in balance.
We also asked questions under the duty to cooperate around GSM traveller accommodation needs. Again, I'm happy that a lot of that really does go to more of sort of soundness and effectiveness of the planning in meeting those needs, unless Tom or anybody else wanted to raise any points specifically about gypsy and traveller needs in the context of effective cooperation. No.
No questions from me in the context that we're in now, no.
Okay. Is there anything else on duty to cooperate then? Any other matters arising under the duty aspect of legal compliance that people wish to raise at this stage that haven't had an opportunity to do so? Ms. Harbridge, you're looking like you might be gearing up for a question.
Yeah, sorry, I might be missing this, but is not the consulting with the public part of the duty? Okay, sorry about that.
Anything else on duty then? No. Okay, which does take us on to sort of the next aspect of this, which is around public consultation. We've got, so just looking at the time, we've got 12:30. We've got public consultation, climate change, public sector equality duty and habitats race. There's still quite a few issues. I think we will go past lunch. What I was proposing to do is probably go for the next sort of 35 minutes or so. So we'll talk about public consultation now before lunch. Do people want to have a quick 5-minute comfort break before we get into that matter? It was a statement more than a question, really. Yeah. We'll have a quick 5-minute comfort break, and then we'll go into the public consultation, and that might bring us up to lunch. Then we can come back after lunch and look at the other elements of duty. We'll literally have a 5-minute comfort break. We'll adjourn and just resume in 5 minutes, please. Thank you. Okay, thank you everyone. We'll resume and continue. So, turn to matters, issues and questions then. Issue 2 is around public consultation. I think, Mr. Harbridge, this is where you, I think it was yourself or gentleman sat next to you, had some concerns. Certainly from the Residents' Action Group, we've sort of seen the representations that have been made. Do you want to sort of introduce then the main issues and the main points where you think the sort of consultation on the plan hasn't been adequate and what your main issues are around that?
Yes, thank you. First of all, they, in the Reg 19, they failed to comply with their statement of community involvement, which states there'll be an online portal, and there wasn't. And this was brought up and they refused to put an online portal in. So it was just limited to inaccessible Word and PDF forms and very cumbersome to fill in. Whereas a portal, each point would have been automatically attached within their database. Substantive objections are largely ignored, and I don't want to go over everything we've put in our statement, but in the early stages of the Greenbelt Review, we did a critique of the Greenbelt Review, which was adopted by Berkhamsted Town Council and put forward to the borough to put alongside it. They never did, and they never contacted us to go through. There's substantive factual errors in that report, which have got carried through to later reports. And it quite often happens when one error gets carried through, it gets magnified as it starts getting going through the process. When we contacted DBC about the Reg 19, they said they're compliant with the regulations, they're doing the minimum. And I think they put that in their statement, they've done the minimum legal requirement. But we say in not providing the portal, they didn't they didn't comply with their SCIs, so that is a failure. Yeah, I don't want to go through the rest of everything I've said on it, but those are main points. Yeah.
Okay, thank you. Mr. Layden, or I'm not sure if you colleagues would just respond on those points, please.
No, thank you, sir. So yeah, I think just going back to with regards to the first point, I think firstly I completely sympathise in many respects, and I think with regards to the nature of an engagement over Reg 19, the technical nature of it always makes things more challenging first and foremost. We have a consultation portal. We changed our online engagement platform in 2023 for the revised strategy for growth. That was allowed us, as part of the Reg 18 process, to ask the right questions the right way. And we had a very, very simple and effective portal for that. That portal was used again for Regulation 19. Let's talk to Dacorum.com. All our evidence library, as you see it online today, is the same evidence library in essence that was used for Regulation 19. We basically just added a few documents when we submitted. We felt that was an efficient way of doing it, including quite the document referencing was set out at that time. But I think the point here is mainly about the technical nature and the form, how we went about that. So the council, in short, naturally drew upon the model template used for the Regulation 19 stage. I think many people were caught out a little bit by the difference between the questions being asked in that and the questions being asked in the previous Regulation 18 consultations. And that just goes back to, I think, one of your initial points, sirs, about what you're being asked to test. And I think it's the technical nature that doesn't help the case. And we did the best we could. Anyone who spoke to us, we did kind of walk them through the process and help them through the process. And we updated some of our notes on our website at that stage to kind of help people to fill it out in a hopefully more simplified form and understandable form. With regards to the SCI, I'd only just go back to our Regulation 22 statement, CD 10.1, which sets out how it complies with the SCI. That's reflected again in our more recent statement to you on these particular questions and issues. We make point as a minimum, we meet the minimum requirements is probably the term we use to ensure that we've met the legal duty. I would probably maintain within reason we've, sought to kind of go beyond that as much as we could. And I think the team has done an excellent job in managing the queries and questions through Regulation 19, responding to those points, and just maintain that, we feel that we've met the legal duties on this.
And just, sorry, just to clarify one, am I coming across incredibly loud? May just be me. Just clarify one point. Bragg say no portal, you say there was a portal, SCI says you'll consult on a portal. Just for my simple mind, the link to the online portal that's there in the SCI, the Statement of Community Involvement, you said that changed, but there was nonetheless a portal online. Did I get that right? Okay.
That's right. Because this has been an ongoing process, we had GDPR, we had to refresh our local plan database. We felt it was an opportune time to get everyone onto the new system in 2023, and ultimately that shaped the basis for how we would notify people for Regulation 19. It was actually quite important to many of the processes of how we notify people, how we let people know. But it just wasn't set up, or is not technically great, and there's not many out there to be able to cope with a Regulation 19 response form. What's required in that, and putting it in a manner, I think what we were very worried about is, A, it wouldn't be right and it wouldn't get the right information by putting it into an online form, which I think is the point being made, particularly today. We've said it is quite accessible if we follow a Word document process. Use the form as a Word document. It can be printed, it can be written on, it can be posted in, it can be PDF, it can be kept as that. It can have images and evidence attached to it or appended to it. We felt it was sufficiently flexible and sufficient in light of maybe the challenges of having an online form itself that reflects it. And for that reason, we maintained that actually we felt it was the most appropriate approach with the tools that we had.
Just looking at the bigger picture, whether it was the old portal, the new portal, etc., do you think the council's consultation in any way restricted or inhibited your ability to make representations? Obviously, you've made reps, we've got them, we're going to take them into account. How and why did it limit or inhibit your ability to make representations on the plan?
Okay. In terms of Bragg ourselves, it was more time consuming, it was more difficult to do, but ultimately, apart from taking up our time, which is a voluntary time, we're not spending 8 hours a day. I run a business, I employ people in the area, but then I have to go off and if I want to engage in this, do it. So it took longer for us, but it didn't ultimately limit what we put in because we had the technical capabilities. But we're representing the residents and the community who are absolutely restricted in what they could do. The amount of phone calls we took, the emails, we were referring them to DBC, and yes, they did repost things on and change advice on the website. But let me put it this way, it's a website, it's not a portal. What you would say is a portal, you go into it, you log in, you have an ID on it, and then you start answering the questions, you start loading up files, and they are linked to the parts of the Reg 19 or Reg 18, which we had one on, whichever one, they get linked. That's a portal. A website that they're just updating and putting files is a website that they're putting files. It's not a portal. St Albans use the same portal that we used, I think, for the Reg 18, or DBC used for the Reg 18. Everybody was expecting that to come up the same. It didn't, and it caused a good deal of aggravation, and we believe limited some people in replying. That's our evidence. yes, it's good that you've got a Word document or PDF document for the people that want to write it out and write their things and send it in and do post. You shouldn't limit those people. But when you put in your SIE, you're going to have a portal which aids you to do it because everything's referenced. You've got the piece. You know you don't have to look at one document, write it down, put it in. They didn't have a portal. They say they had a portal. It was a website, and that's the simple fact. It's not it's not old portal, new portal. It wasn't a portal.
Okay, thank you. Yeah, the lady to your left, CPRE.
Yes, and my comments aren't about the portal. Is it okay to carry on? Question one? Yeah, okay. So our specific point on this is the lack of consultation on two housing sites, HM11 and HM13, that were put in to the submission plan without time for consultation. So as far as we're concerned, this is in contravention of the council's own SCI. So we obviously, as an organisation that works a lot with the community, we had lots of complaints about this and people were quite unhappy about it, and that is particularly in relation to the Shendish Manor site. So looking at the council's statement, the argument for putting that site in, I believe, was because it could contribute to SANG, and we understand the need for SANG, and there's a circular argument about how important it is to protect the Chilterns Beechwoods, but we still say that there was no clear and navigable opportunity for the community to make their comments known on both sites, but particularly the Shendish Manor site. So I don't think they've met the requirements on that.
When just talk me through that. So when you said there was no consultation, just explain why you feel there's no consultation.
Oh, okay. So for a member of the public to be here, but this is where we're reviewing the submission plan, they would have had to have specifically objected at an earlier stage to these sites being included. So they can't be involved at this stage.
They would have had to object at the Reg 19 stage.
Yeah.
Yeah. So what prevented those people from objecting at the Reg 19 stage? You referred to two sites, did you? So are those sites that are in the submitted plan?
Yes. Yes. Oh, sorry. So it's the fact that they weren't in the Reg 18 consultation that would have given the public the opportunity to get involved at that stage.
Okay, so they're in the Reg 19 plan.
Yeah.
They're in the Reg 19 plan. The council consulted on the Reg 19 plan. People could have made representations in response to the Reg 19 plan, and off the back of that could have attended these sessions. So from the council's point of view, why do you think that was sort of either procedurally unfair or didn't accord with the council's sort of policies and procedures on public consultation?
Yes, so because they weren't content in Regulation 18, most members of the public would have been able to comment if they had been in the Reg 18. But Reg 19 is a different thing for little community groups, residents groups and individuals. It's much harder for them to comment at that stage. In fact, most don't, in fact.
So just from the council's point of view then, where you've got this situation where sites come in at Reg 19 stage. How did you sort of try and address the points that CPRE and local residents are making? Because obviously, yes, if it's not in the draft plan, they wouldn't be aware of it. How did you as a local authority then actively seek to engage those people? And how importantly does that then sort of accord with the SCI?
Thank you. So I think just on that particular point, there's probably just a couple of points in relation to that. So I think the important first distinction is that these sites were considered at various stages of the process, not just at Reg 19. In terms of, these sites weren't sprouted up out of nowhere in 2024 and suddenly they were in that. And I'll just probably, just to go back on a few points, the Issues and Options Consultation Report, CD 10.3, we received many comments with concerns about an allocation at Shendish Manor. It's just, I won't say a find function and put in Shendish from 2017, you'll find that there was a number of comments and concerns about growth at that. And in 2020, RSA report for the Emerging Strategy for Growth showed and appraised both of those sites in 2020. And just a note, we're in the consultation report for that CD 10.4, again, recognition both sites were actively promoted. The revised strategy for growth didn't include either of those sites, so I think that's been clearly spelled out. But the interim SA report, again, considered both of those as variables within the reasonable alternatives appraisal process. But importantly, I think too, in 2023, the revised strategy for growth consultation report, the Kings Langley Parish Council, and there was wider comments made from the public in 2023 to the exclusion of Shendish and general support about it. So we actually do have a timeline here where demonstrates that people have engaged in the process, and even though they've never technically been allocated, we have reflected them both within our evidence and the consideration of alternatives, and also, in terms of the consultation reports and the summaries of key issues raised at each stage. So just turning to the point about how we engage with that, again, just going back to the point on our statement of community involvement, it's just reiterating the point that we have met the legal requirements of that, and that's the starting point. I think when it came to being very clear, when we took the plan to full council and cabinet full council, it was subject to scrutiny as well. There, many concerns were raised by local councillors, etc. And our reports equally set out quite clearly the changes to the plan and why these sites were being included. And that was for the elected members to consider and come and decide upon. And that's just something to note as part of the process leading up to this. In terms of how we've engaged, I would just say we have sought to do all that we can in terms of engaging. And just going back to maybe also the point Bragg had raised on this, how we've reached out, how we've engaged. Yes, we have a portal, but we've also put adverts in the newspapers. We've also put hard copies of the representations forms in libraries and the core documents within the libraries. We notified 3,844 people for Regulation 19. In terms of our responses, I would say we've had a very, very strong and healthy response to that. And I think it's very, very clear that the allocations of Polehanger and Shendish Manor are key issues we've appropriately reflected in the Reg 22 statement. But just on the point about, if I can, about we've very much tried to reach everyone. It's how far we can do that in the context of GDPR and what people want and do not want to be notified. But just on the point about the portal itself, and I don't want to draw too many comparisons with our neighbours on this, but reference was made to the objective console, the system that we used. And I just note that I think St. Albans for their Reg 19 used that system as their main point for directing responses towards. They received 262 representatives to their Reg 19. We received 1,590 representatives to our Reg 19. So I think on that, in terms of how we've reached out, how we engaged, I think we've done the best that we can on this in light of the requirements.
Thank you. And I'm taking something a little bit out of sequence, but it is here in the, I think it was the hearing statement of Green King. It's maybe also in what CrowdAce have commented on this issue. But can you give me the document references to where things have changed? So whether that's allocations that have come in or gone out between Regulation 18 and Regulation 19. If you've got the document reference to hand, that would be very useful. I'm not going to go into it now, but just in terms of allowing us to go back and to look at those arguments that have been made, to see the council's position, but also for future sessions, that would be very useful. Thank you.
Just to add, if I can, on that, the main one is core document 10.6, which is the summary of changes to the spatial strategy and site allocations. That was published in November for Regulation 19. That set out the change in the strategy, how it's evolved with regards to sites, and what was in and what was out at various stages.
Thank you. That's very useful. Thank you.
Yeah, thank you, sirs. I just have to respond to them quoting stats from St Albans saying 290 responses to them and 1,300 to this. It's got nothing to do with the fact that they did it properly. It's the fact that we managed to generate people's interest in it, and once they got to know about it, they wanted to do something. They got 1,300. It would be nice to compare it to other stats. I mean, there's a planning in at the moment that's got well over 1,400. We engage. So the fact that you've got one planning permission with over 1,400 objections in against it now shows that we've engaged down. They're boasting about 1,300 for a local plan, which should engage the whole of Dacorum. I don't think that's really relevant stats.
Oh yeah, anything else on public consultation? No? Bristow, anything for yourself in public consultation? Next on the list, I believe, was climate change, but I'm also mindful of the time. It's come to 1 o'clock. So a bit of a sort of vote, really. People happy to take lunch now? We'll resume at 2 o'clock. Obviously, the programme was always scheduled to do this, or is anybody needing to sort of leave immediately after lunch that wants to make a point now? People are happy to adjourn for lunch and come back at 2 o'clock to pick up issue 4. Yeah. Okay, thank you all for your time. We'll adjourn exactly 1 o'clock and we'll resume back here at 2 o'clock. Thank you.